All right, let's dive into one of the most powerful and frankly fastest tools in the entire legal system, the injunction. Think of it as the law's emergency brake, its giant pause button, and its shield all wrapped up into one incredible package. So, picture this. A former employee is literally hours away from blowing your company's biggest trade secret all over the internet. Winning a lawsuit for damages a year from now? That's not going to help. The secret will be out, you need to stop them, and you need to do it right now. So, what can you do? Well, the answer is an injunction. See, this isn't about cleaning up a mess after it's been made. It's about stopping the mess from ever happening. The legal world calls this preventive justice. And honestly, that's the perfect way to think about it. It's a direct order from a judge saying, stop what you're doing, or sometimes, you need to do this. Okay, so this idea of preventive justice, how does it actually play out? Well, at its very core, it's all about hitting that legal pause button. And the key phrase you're going to hear again and again is status quo. You've got to understand a temporary injunction isn't about deciding who's right and who's wrong. Not yet. It's about freezing the chessboard. The court is basically saying nobody makes another move until we can hear the full story. The goal is simple: just stop the situation from getting any worse. And this is not a new idea, not at all. It was actually born out of pure frustration way back in medieval England. The regular courts were, well, they were really rigid. They could only give you money after the damage was done. So your neighbor floods your farm, and the court just says, here's some cash. Not very helpful, right? So people started going straight to the king's chancellor, the keeper of the king's conscience, who could make decisions based on what was just plain fair. And that's exactly where the injunction came from, this need for a smarter, more flexible solution. So this brings us to the two main flavors that an injunction can come in. And this slide just lays it out perfectly. On one side, you've got the prohibitory injunction. This is the classic, the one you'll see most of the time. It's a giant stop sign from the court. Stop trespassing, stop building, stop publishing. Simple. But then, on the other side, you've got the mandatory injunction. This one is a go order. It forces someone to do something. Demolish that wall you built illegally. Return those documents you took. Now, here's the crucial thing. Courts are way more hesitant to grant these go orders, especially before a full trial. And it makes sense, right? Stopping an action just freezes the board. It preserves that status quo we talked about. But forcing an action, like making someone tear down a wall, that creates a whole new reality. And what if the court later finds out it made the wrong call? You can't exactly undemolish a wall. But what happens when the situation is even more intense? When the stakes are even higher? Well, for those extreme cases, the law has developed some very specialist, very powerful tools. I mean, think about this scenario for a second. You've been defrauded out of millions. You know the person has the money in a local bank, but you also have very good reason to believe they're about to wire it all to an offshore account where it will vanish forever. A simple stop order isn't going to cut it. And that is where the Merava injunction comes in. You can think of it like a financial freeze ray. It stops a defendant from moving or hiding their assets to make themselves judgment-proof. That's a fancy way of saying they can't empty their bank accounts, so there's nothing left for you to collect when you eventually win your lawsuit. But getting one is not easy. You can't just get it because you have a better feeling. You have to walk into court with a good, arguable case. You have to prove the assets are actually there. And here's the kicker. You have to show a real risk that those assets are about to disappear. A mere suspicion just isn't going to be enough. Okay, now if you thought that was intense, get ready for the Anton Pillar order. This thing is on a whole other level. It's often called a draconian measure for a reason. We're not just talking about freezing things anymore. This is a surprise civil search warrant. It lets you enter someone's property to search for and seize critical evidence. Yeah, this is basically the law's nuclear option, and it's reserved for the most extreme situations, like copyright pirates or people who've stolen vital trade secrets. Just look at this list. The bar is incredibly high. You need an extremely strong case, the potential damage has to be massive, and you need clear evidence that the other person is going to shred or delete the proof the second they get a whiff that you're coming for them. It's a true legal preemptive strike. So, with all this incredible power flying around, you have to be asking, how do courts make sure this isn't abused? And that brings us to the crucial balancing act that is at the very heart of every injunction. When a judge is deciding whether to grant a temporary injunction, they follow a pretty famous test. First, they ask, is there a serious issue here? It can't be some frivolous claim. Second, and this is really the most important part, they weigh the balance of convenience. And third, if it's still kind of a toss-up, they'll usually just default to preserving that status quo. So what on earth is this balance of convenience? Well, it boils down to this single, incredibly powerful question. The judge has to figure out what the bigger mistake would be. Is it worse to grant the injunction now and later find out it wasn't necessary? Or is it worse to refuse the injunction now and later find out it was desperately needed? It's all about who will be harmed more by the court's potential error. And here is the system's critical safety net. To get an injunction, you, the person asking for it, have to make a formal promise to the court. It's called an undertaking as to damages. You're basically saying, Your Honor, if you grant this and I end up losing the main case, I promise to pay for all the financial damage the other party suffers because of this order. This is huge. It makes sure you've got skin in the game and aren't just using this powerful weapon lightly. Okay, so for our final section, what happens if someone gets one of these court orders and just decides to ignore it? Let's look at the consequences. And let's be absolutely clear on this. An injunction is not a polite request. It carries the full weight and authority of the court. So willfully disobeying it has a name: contempt of court. And the justice system sees that as a direct attack on its own authority. And the penalties are severe. This isn't just a slap on the wrist. We are talking about substantial, sometimes crippling fines. We're talking about the court seizing your assets. And yes, in the most serious cases, we are absolutely talking about imprisonment. These orders have very real teeth. And this is not just a theoretical threat. This quote right here comes from an actual Malaysian case about a recording contract dispute. It's a stark, real-world reminder from the High Court that its orders will be respected and that open defiance can and does lead to a jail sentence. So in the end, the injunction is this fascinating legal puzzle. It's a vital tool for swift, emergency justice, but it works by restricting someone's freedom before they've even had their full day in court. It's a constant tightrope walk between protecting one person and preserving the liberty of another, which leaves all of us with a pretty crucial question to think about. Where should that line ultimately be drawn?